during the live stream. Just beware that anything we say will be picked up by the live stream. All right, Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We are here this morning for oral argument in cause number CV180271 MW2 Investments versus IMH Special Assets et al. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. For cross-appeal, counsel for appellee may reserve a portion of that time for rebuttal to address only the cross-appeal issues if desired. Also, we have read the briefs in this case, have discussed the case, are familiar with the facts. Keep that in mind when allotting your time. At this point, counsel, are you ready?
Your Honor, before we begin, can I inquire about my time limit? My client is only a party to the cross-appeal. I won't take it.
All right. If you had to estimate how long you think your portion of the argument would take, how long? Okay. Well, you can't divide it between the two of you and get everything done. So what we're going to do is add 5 minutes to each side, and we'll take a little bit of time away from you. So that's what we're going to have to do this morning. All right? Okay. Let's begin.
Good morning. My name is Jeff Prepper.
One second.
Oops.
We're setting the clocks. Excellent. Thank you. All right.
Good morning. May it please the court. My name is Jeff Proper. I am an attorney representing MW2 Investments, both in its individual capacity and on behalf of Siegelville LLLP, a limited liability limited partnership. We're here today because, in essence, MW2 and Siegelville have a right and have been denied a remedy. MW2 has attempted to proceed in the receivership proceedings, which this court, I'm sure, has read much about in the briefing. And
Let's talk about the receivership proceeding.
Sure.
Because it is the crux of the entire thing. When MW2 submitted their claim to the receiver, when we're looking at the document that explains why it was denied, it says no support or amount was included with the claim alleged, equity interest in multiple entities. There was an alleged transfer of interest to simple post-receivership that was not authorized. The receiver has potential claims against the claimant. What happened there? Why did we not do anything in the receivership proceeding when that was denied?
we did.
You moved to intervene,
We moved to intervene before that.
Right.
That was denied.
right?
We were told we couldn't appear unless we filed a motion to file a motion, which in my 47 years I've never heard of before. And we appealed from the denial of that claim. And that appeal was part of a series of appeals which arose out of the receivership proceeding. I don't know how many there were. There may have been a dozen, there may have been 6, but there were a lot of appeals, all of which arose out of that underlying receivership proceeding. The Court of Appeals consolidated all of those appeals and stayed them pending its decision on the main claim by Maniatis that the judgment was void. The judgment amount was wrong, and that resulted ultimately in the Court of Appeals reversing the granting of that judgment and sending the case back to the trial court for proceedings not inconsistent with the court's ruling. At the same time, the Court of Appeals dismissed as moot all of the related appeals, which means that once the judgment went away, all of the appeals that arose out of the judgment in the receivership proceedings were deemed moot. Those presumably are all going to be back up before the Court of Appeals when and if there's ever an underlying judgment that's entered in the Aperian underlying case.
And that was my next question. What is going on in that case?
Well, there is no final judgment. There have been a series of, I will call them mini trials on certain related issues, the first of which was the amount of the judgment.
Right.
Then there have been a trial maybe a couple of weeks ago with some intervening parties called the Beck parties. There have been some motion practice. There's current motion practice. There's a Rule 59 motion for new trial pending. There have been some recent motions filed by Maniatis's counsel which challenge the jurisdiction of the court to have entered the receivership orders in the first place. So there is a whole series of underlying motions which will presumably delay the finality of whatever judgment Judge Smith is ultimately going to sign in the underlying case. He has set, most recently, like yesterday, I think I got the order, an order to finish the briefing, because in the midst of these motions, Maniatis wasn't sure whether or not he had to appeal certain orders, so he filed some interim appeals, acknowledging that they may or may not be ripe. Those now have all been stayed, and the matter remanded back to the trial court in order to finish the current motion practice that's pending before the trial court.
Thank you.
Okay. We think there's a couple of fundamental errors in the trial court. As the court is aware, and I don't want to belabor, this is an appeal from a motion to dismiss. The scope of review has been argued differently by counsel, but we're pretty satisfied that our scope of review, which is de novo, is appropriate. The judge at the trial level relied entirely for his decision to dismiss the complaint on the Mashny case and the sanctity of the receivership orders. He went through some analysis to say, well, the judge said this was okay, and the judge says that was okay, and all the things that you're complaining about were raised in the receivership proceedings and ultimately blessed by the two judges that handled the receivership. He never discussed whether or not IMH could be liable vicariously for the claims and the factual recitation that was alleged in the original complaint. While the receiver may, not necessarily does, but may have immunity, judicial immunity, from claims that MW2 and others might make against him for his conduct in the receivership proceedings, that begs the question as to whether IMH can be liable for conspiring with and aiding and abetting the creation of wrongs that were done in the receivership proceeding, the first of which was the issuance of the receivership order in the first place. That receivership order was premised on 12-1241. In fact, there are a series of statutes under the partnership laws, which we've cited in our brief, which really govern what the trial court had the authority to do and had the authority to issue in this case. The receivership order went way beyond anything that was permitted by 29-341 and 29-1044.
And we keep coming back to, why wasn't it dealt with in that case? You've still got an appeal pending. It was dismissed as moot. You say you're going to bring it back up about the denial of your claim in the receivership proceeding. Why isn't that your venue for pursuing this?
Well, once there was a final order entered in that case and it went up on appeal, MW2 really was stymied in what it could do to try and collect money that is clearly owed to it as part of its interest in Seagoville. So here's the risk. The risk is that MW2 sits out there and waits for the appeal to come down. And by the way, the approval or denial of its claim is not the beginning and end of MW2's rights and remedies that it can assert against IMH. The proof of claim and that appeal only dealt with MW's claim that it should have received money from the receivership estate for its 17% interest in Seagoville. It doesn't have anything to do with, although the amount may be the same, with the claims that have been made against IMH in the underlying case. In addition, by sitting by and waiting for the appellate decision to come down, or the Supreme Court opinion if it went upstairs, MW2 runs the risk that any other claims that it might have against IMH would be barred by the statute of limitations. In fact, that was one of the arguments that was raised by IMH in its motion to dismiss at the trial level. So MW2, quite frankly, is in a crack in the legal system. It can wait and see if the appellate court reverses the denial of its proof of claim and go back and argue that. But while it's waiting to do that, its other claims directly against IMH might ultimately be time barred. So it needed to file the action that it filed in order to preserve those claims. Admittedly, there are claims in this case, in the trial court, which might be better suited for decision in the Aperian case, in the receivership case. But we're not going to know about that for quite a while. We have to get through a final judgment. Then whatever appeals are going to emanate from that final judgment are going to go upstairs to you folks and to probably the Supreme Court. And then depending on whether or not that case gets reversed yet again on some of these critical issues, some of which we've raised here, is unknown. So in the meantime, we either sit by and wait or we affirmatively pursue the claims that we believe that we have directly against IMH for both actions that were done during the receivership proceedings as well as post-receivership actions. For example, the accounting claim, which is just, to me, a pretty clear example of what we're entitled to as a partner of Siegelville. The judge just swept that away in saying, well, everything the receiver did was blessed by the trial court and by the receivership court, and therefore you have no claims. It never discussed whether or not we have direct claims against IMH.
When we go back to looking at the way this case has progressed through the receivership and also in this case, isn't your client, I don't know how to say this. This is a very confusing case, number one, because it's...
For sure.
Got it. Isn't Maniotis the bad actor here?
Well,
He was
your
the
question is
general partner.
it's a very interesting question, okay, which leads to an answer that is kind of the part of the heart of our brief and the reason why that we're here. I don't want to characterize Maniotis one way or the other, okay? But yes, the allegations that are made against him is that he had a big judgment against him. He had a whole series of interests in a bunch of trusts and partnerships and limited liability companies and limited liability, limited partnerships. And this started in the receivership proceedings wrongfully. And when I say wrongfully, it's because we have a statutory scheme enacted by the legislature under the Revised Uniform Partnership Act and the Revised Uniform Limited Partnership Act, which does specifically one thing in changing how the law was prior to that time. Originally, in the world of partnerships, a creditor of a limited partner or of a partner, if it was a general partnership, had the right to get to the partnership property for the debt that was owed by one member of that partnership. And that was the law until the Partnership Act was revised. And now you can only get a charging lien. So I have no objection, I have no problem with the receiver doing what the receivership statutes and the partnership statutes allow them to do. One, preserve and protect, not aid in execution. Number two, they can only get to Maniotis' transferable interest in the 158 entities that they belatedly added to the receivership order.
Let's get back to Maniotis. As the general partner, he engaged in a bunch of shenanigans during discovery, right?
Presumably, yes.
He did not disclose that MW2 owned a certain part of Siegelville. They had to ferret that out. Isn't that true?
Well, I can't tell you what was in the mind of the lawyers and the principals at IMH. I will presume, for the sake of your question, that in fact Maniotis was difficult, and in fact IMH had to do a lot of work to figure out how many entities he had interests in.
Okay.
But that begs the question of what a creditor is allowed to do once it's determined that Siegelville LLLP has Maniotis interests within it. It can't get to MW2's interest. And what is really frustrating in this case is that on two separate occasions, one by IMH's counsel and one by the trial judge, they said, well, MW2, you don't really need to be here because the receiver doesn't have any authority over your interests. He can't sell your interest. And IMH and the receiver, in their joint motion to approve the Siegelville sale, represented to the trial court that they were going to get together with the other partners and discuss how they can protect their distribution if the sale is allowed to go through. Guess what? $1,900,000 and some odd gets apparently paid for Seagoville's interest in this Texas property. How much of it went to Seagoville? It's kind of a rhetorical question. Zero. That's how they dealt with the limited partners in this partnership once that money was produced from that sale. So that representation in the joint motion to the trial court is just false. It was a lie. And the trial judge, when Mr. Halstead went back up, before he filed this lawsuit, he went back up to try and get the trial court in the receivership proceedings to clarify what MW's position was in this case. And you've got the citation and the quote in the briefing. The trial judge said, "I feel your pain." Well, her pocketbook didn't feel our pain. Our pocketbook felt that pain. We had a right in excess of $300,000 from the sale of that Seagoville property, and we got zero. All of the money went first to IMH, and then they did whatever they did with it under some intercreditor agreement that obligated them to divvy up what they got out of this deal to other Maniatis creditors. That money belonged to Seagoville, not to the receiver. The receiver was entitled to one thing from the sale of that property, whatever Maniatis' transferable interests were.
Can I back you up a little bit?
You may.
I just want to, it seemed to me that earlier you were suggesting that in large part that this bus is being driven by the Aperion litigation, or could be driven by what happens in the Aperion litigation.
Yes, in part.
In part. Would it make sense for us to stay this appeal and wait for resolution of those matters?
Good thought. I had the same thought. Okay.
Because this seems like such a kerfuffle that we might be better sort of waiting to see what happens there.
I could leave now if I would be happy to do that, Your Honor. I had that same thought because here's where we have the right, as we've argued in our brief, to ultimately challenge the subject matter jurisdiction of the receivership court independently, based on the citations that we've given you. That issue is now before Judge Smith in a motion that was recently filed by Maniatis, and I'm going to guess, just based on the history of that receivership proceeding, that motion will get denied and it will be up on appeal. And this court, whether it's you three or somebody else, is going to be taking a look at our brief in this case, which talks about the limitations that this receivership court had on charging Maniatis' interest in these various entities and then taking everybody's money, way beyond Maniatis. They got $300,000 of what should have been our money. So that issue is before the Aperion court and is going to be before that court. And yet, by case law, we have the right to raise that issue in our proceedings. And we have sort of done it as sort of a fallback position to say that if you think we don't have any claims that would survive the sanctity of the receiver, okay, then we raise the issue that those orders on which he acted are void, and the court did not have subject matter jurisdiction to do them, and our trial court would have the right in our case to resolve that issue. I quite frankly think it's raisable legally in our case, but it's better suited to be resolved in the receivership case for what hopefully will be a different judge who will be able to take a look at the 1,400 entries in that case and try and figure out whether or not the new partnership statute's really limited. That it's really not a complicated issue. It's really whether or not the trial court had the authority to impose the type of receivership order, in this case, in the face of 29-341 and 25-1044, and the fact that partnership property is no longer property of the limited partners. It's a separate entity.
Counsel, I'm going to interrupt you because there's only 5 minutes and 23 seconds left of your time. I think that the cross appellee requested some of that time, which is not going to be much. So it might be time for you.
Yeah. So, I think the briefing is well done in this case, and I don't want to belabor what we've said, but I do think there's the two issues you have to deal with are our rights to go against IMH for vicarious liability, allow the complaint to be amended at the trial level, and the second prong is whether or not we've alleged claims in the underlying lawsuit that don't have anything to do with the sanctity of the receivership orders and any issues of vicarious liability.
Thank you. I'm going to let you go after him, or do you want, okay. Please proceed, counsel.
May it please the court, Benjamin Reeves from Snell and Wimmer on behalf of the defendants' appellees. Before I get into my presentation, the whole partnership statute argument was not raised below. That's waived. That has been raised repeatedly in the receivership court. That would be part of the record if it was raised below, but it wasn't raised below, so we didn't attach those pleadings. But it was raised repeatedly in the receivership court and denied. So that's a non-issue. It's been fully vetted. For my presentation, I will first explain why the appellees prevail, and then second, I'll explain as to our cross appeal why the prosecution of this case merits sanctions under either ARS 12349 or Rule 11. Appellees prevail in this case primarily because of claim preclusion. The appellants misunderstand our defense, and they think we're arguing only judicial immunity. That's not it, although that's a factor. MW2's right to receive funds from the sale of the Seagoville property was litigated and decided adverse to MW2 in the receivership action. That's claim preclusion.
When we talk about claim preclusion, counsel, don't we need the same parties?
And the best example of claim preclusion is the claims order, which I appreciate that Your Honor focused in on. MW2 submitted a claim. By submitting a claim as a matter of law, it submitted itself to the jurisdiction of the receivership court.
But was denied the opportunity to intervene as a party.
The claim submission process itself makes submit yourself to the jurisdiction
I get
of the
that
court.
they submitted themselves to the jurisdiction, but they were not allowed to file motions, they were not allowed to intervene, and they were not allowed to pursue their own interest in that receivership, from what I can tell from the record before me.
And the record shows we attached several motions. We never stopped them from filing motions. They filed several motions. And to the point of the court was so concerned about the disruption that MW2 was causing and the conflagration of the whole litigation that MW2 was causing, they said, stop, MW2, you're doing too much. Get permission before you file anything else. So they did participate. Did they formally intervene? No. We cited a bunch of case law in our papers for the proposition that a non-party who interacts and engages in a receivership court is deemed a party for the purposes of litigation below and appeal. So I think as a legal matter, even though they were technically denied the right to intervene under Rule 24, they effectively participated substantially, significantly, and it's particularly in regard to the claims order. They submitted the claim. The receiver objected to the claim, and that's attached to the motion to dismiss at 35. MW2 responded. That's attached to our motion to dismiss as Exhibit 36. That, again, Your Honor, shows active participation at a minimum in that proceeding. And then the MCA, or the receiver, replied, and that's motion to dismiss 37. And the receivership court expressly rejected MW2's claim, meaning that MW2, as a matter of law, had no right to share in any distribution from the sale of the Seagoville property.
I know this is not the receivership appeal. This is a motion to dismiss, but you have to get into the receivership to understand the motion to dismiss, quite frankly. So you, in the receiver, acknowledged that MW2 had somebody had an interest. I don't know that it in Seagoville besides Maniotis, correct?
Correct.
And who do we know had that interest? MW2.
Actually, at the time of the sale, MW2 did not own an interest in Seagoville. And if you go to our joint sale motion, which is appended to our brief, there's a schedule of the owners of Seagoville. And
Which is where I got that you acknowledged that Maniotis didn't own 100% of Seagoville.
Correct, and I believe there were two other owners amounting to 2.3%, something like that.
So you acknowledged that somebody owned a portion of Seagoville besides Maniotis.
Correct, and
Okay, go ahead.
can I ask what the point of that is, or why that's important to Your Honor?
Why it's important to me is this. If MW2, and I don't have any of the appeals, but if MW2 truly was a part of Seagoville, and they're engaging in this litigation with the receiver, they're thwarted at every stage, where were they supposed to find redress? That's what I'm having trouble figuring out.
They litigated and lost the issue, and maybe I'll just put on maybe an example will help us wrap our heads around it. The case law that we cited below for the proposition that you submit a claim, you submit yourself to jurisdiction is SEC v. Wells Fargo 848 F3rd 1139.
I get that they submitted to the jurisdiction. That's not what I'm asking you. What I'm asking you is this. If their claim is denied, and you acknowledge that Maniotis didn't own all of it, somebody did. Somebody had an interest. Did that somebody that you think had an interest get their portion of the Seagoville sale?
It was the final distribution of, so whatever anybody was entitled to in the receivership, they got through either the interim distribution order or the final windup.
And those were major creditors. I'm talking about, let's do a hypothetical that makes this much simpler. I hope. Keep your fingers crossed. It can get kind of convoluted. Okay, you and I enter into a partnership. I give you a 1% interest and we own a chocolate chip cookie, okay? The chocolate chip cookie gets put into a receivership. You have a bite that you're entitled to. The rest of the cookie, my creditors are going to take. Who got the bite of the cookie in this case?
The people who received the distribution from the receiver got the cookie. And the point, the claim preclusion point is if the judge's ruling was right, wrong, or indifferent in regard to the cookie, it doesn't matter. It's a final order. We can't revisit that.
And that is being...
And they can't appeal it?
They did appeal.
And where
That-
it was dismissed as moot.
That appeal was dismissed as moot. They should have appealed that. This is, they don't get to just ignore final court orders under claim preclusion. It's just that we need finality. You can't just say, well, I got hosed in this case, so I'm going to ignore everything that happened in that litigation and proceed anyway. And let me give
Let me
you...
ask the same question I asked the opposing counsel. It does seem, and it sounds like you're maybe partially acknowledging this, that the Empyrean litigation is driving this bus. Wouldn't it make sense for us, or would it make sense for us to stay this decision pending what happens there?
I don't think so, Your Honor. The appeals from we call them the controlling receivership orders, the claim order, the distribution order, the wind-up order, those are all already dismissed. They're gone. We have a judgment, a final judgment signed. It is nunc-pro-tunc back to the original judgment date. There have been 2 Rule 60 motions, 2 Rule 59 motions filed. Those are going to be briefed. They raise a whole bunch of issues that have already been raised. But as to the claims order, the distribution order, the wind-up order, those are final.
Is there no chance the Empyrean litigation would find the entire receivership be improperly set up, established?
The receiver's been discharged for years. I don't see
Is that an issue that's pending?
that. Well, there's no appeal. So they've appealed the judgment and another appeal, and they're re-raising everything that they've raised before. It's all been litigated adverse. They've lost in every issue, and maybe this hypothetical will put the MW2 theory in perspective. So let's say a company, we'll call it Seagoville, sold some property for $2 million. Okay, let's say some creditors come and make a claim to that $2 million. Let's say MW2 also comes and makes a claim to that $2 million. What does Seagoville do? It interpleads it. Okay. And Siegel says, court, you decide how to distribute this money. I understand MW2 says they're a partner, they want the money. These creditors over here say they want money. Court, you decide, I've interpled the funds. It's litigated, and MW2 loses. Okay, and the court distributes the funds to the creditors. 2 years later, MW2 sues IMH and says there was a conspiracy between the creditors and the court to distribute that $2 million to IMH, and I'm entitled to my piece of the pie because I'm a partner in Siegelville. And we say, when we see the complaint, we say, hold on. One, we got that pursuant to a court order, so you're barred. And two, there's no conspiracy with the judge because of judicial immunity. And they say, you're right, I can't sue the judge, that's why I'm suing you. That's MW2's theory in this case. It makes no sense to me, Your Honors. That's their theory.
And we've gotten completely off track into the receivership. And we're here about this case. So let's talk about this case.
That's their theory. It's literally, I can't sue the receiver. I'm really upset about what the receiver did, so I'm suing IMH for vicarious liability. Notice that there's absolutely no case authority supporting a vicarious liability. How can I be vicariously liable when the receivership court approved every single action of the receiver? As a matter of law, that means the receiver engaged in no wrongful act. As a matter of vicarious liability, if the receiver engaged in no wrongful act because all of his actions were approved, I can't be vicariously liable. So their theory doesn't even get off the ground. And this is based on their own words. And I want to focus, read from their opening brief to focus this discussion. And this is page 9 of MW2's brief. It says, whether the receiver is immune from suit by plaintiffs is not dispositive of the claims presented against IMH. Plaintiffs have repeatedly pointed out that they do not seek to impose liability upon the receivers or overturn the various rulings and orders of the receivership and other courts. So let's take them at face value. They're not seeking to overturn the orders in the receivership court. That would include the original order appointing receiver. That's their own statement. So in this case, this is in their brief. And they've said that repeatedly because they know that they can't sue the receiver because he's judicially immune. So I'm upset that I can't sue the receiver, so I sue IMH. Here, they're admitting that they're not seeking to overturn those orders. So their final claim preclusion applies. We're not going to use this action to go as a substitute appeal from those otherwise final orders of the receivership. We have to play the ball where it lies.
How do you address their statute of limitations issue? Let's say they did have a valid claim, hypothetically. And so they file this lawsuit to toll the statute. What else are they supposed to do?
What's their claim?
I said for the case of this hypothetical, what were they supposed to do?
Well, one point, we only raised the statute of limitations argument in regard to their negligent misrepresentation claim, which, by the way, claim that we misrepresented the value of the property, but then their fraud claim says we didn't tell anybody the value of the property, so those are internally consistent. But if they don't, they're trying to invent a remedy for a perceived wrong. They don't have one. You can't just say, well, I think I'm entitled to $300,000, so I'm going to sue whoever I want. There's no claim there. So if a statute of limitations of the non-claim runs, that's just how our process works. I'm not personally offended by that. If I have a claim, I know I need to timely assert it. I'm not persuaded by we were scared that we were running out the clock on what? They haven't asserted any valid claim against us. You're complaining about actions the receiver did years ago, and the remedy was to appeal. And if they didn't like the disposition of the appeal, that's why we have a Supreme Court. They didn't do that. They just let it lie.
When the appeal is dismissed as moot, though, especially in this circumstance where relief was granted in a subsequent appeal, the implication, either direct or implied to that, is that they can reassert these claims now, but we've remanded the case back, and that's why the appeal is moot. Why is this one different? You're treating this dismissal as a dismissal in traditional litigation parlance as prejudice, It would seem to be kind of without prejudice dismissal.
So the dismissal of, let's say, the claims order appeal?
No, the dismissal of their appeal.
This-
You're
sorry.
suggesting they should have appealed the dismissal with, as moot to the Supreme Court.
If
When
they didn't
it
like,
was dismissed as moot because they're saying we're sending it back for the court to do more, and then we'll consider these appeals subsequent.
the Court of Appeals didn't say that. And in fact, I can't remember if it was Mr. Semple in his capacity as MW2 or NDM, they filed a motion to clarify or something to address the issue of the dismissal as moot, and the Court of Appeals said, not having it. These appeals are dismissed. And it didn't remand with instructions to do anything with regard to any of those, I think there was a dozen appeals.
But it set aside a major portion, the prior decision by another panel of this court set aside portions of the receivership order. No?
The amount of the judgments.
Yeah.
Correct.
So they had set aside portions of the receivership order and said that the fact that there no longer is a final judgment rendered all these claims moot. That doesn't mean that they were dismissed on their merits. So how can you argue claim preclusion when there hasn't been a final judgment?
No, so the mandate, only, it vacated the judgment because it said there was an issue of fact that precluded summary judgment. After the mandate issued, we filed a motion for reconsideration asking the Court of Appeals to reconsider that, or in the alternative, because all this post-judgment activity had taken place, instruct the trial court to enter the judgment nunc-pro-tunc back to the beginning so that we have a judgment in place that supports all this post-judgment activity. So that's what the Court of Appeals did. The Court of Appeals didn't touch any of the post-judgment rulings. And those were appealed, and those appeals were dismissed. And again, unless, as a matter of Arizona law, unless there's an order vacating an order, it's valid. So we need a Court of Appeals order to vacate any trial court order, otherwise it remains valid. And that's why if there's no appeal, trial court order is valid. If appeal is denied, trial court order is valid. If an appeal is dismissed for any reason, the trial court order remains valid. So those orders, the controlling receivership orders, I think are preclusive. They are binding and they are final. So I think those in and of themselves, one, preclude them.
Are they appealing now the reinstatement of the nunc-pro-tunc signing?
Mr. Maniotis has appealed the nunc-pro-tunc judgment, and there was a second receiver. I don't think that's important here, the discharge of that receiver. But those have been remanded to deal with the post-judgment, post-trial rulings.
Thank you.
So getting back to MW2's words in this case, one, again, they're not challenging the receivership court orders. They're not asking you to make a decision that says, well, the receivership order itself was improvidently granted, so we're going to ignore it. And I don't think there's any case law for that. Second, MW2 continues on page 9. It says, rather than sue the receiver, because we can't, rather, plaintiffs seek to impose liability solely upon IMH based on its vicarious liability arising from the wrongful acts of the receivers during the receivership and or its own wrongful acts and omissions post-receivership as general partner. So Ken, this ever-evolving theory of vicarious liability, there's no support for that. There's no case law cited in the brief to support that. There's also, now they bring up post-receivership wrongful acts, and we heard Mr. Proper say, well, an accounting. Well, they didn't ask for an accounting because the only transaction that they're concerned about is the receiver's sale of the Seagoville property. So that's entirely bogus. MW2 continues on page 9 of their opening brief. This, however, does require some threshold showing that the receiver's acts and omissions, though perhaps immune, were wrongful. So MW2 acknowledges that it needs to show, even though it's convoluted theory, it needs to show that the receiver did something wrong. And that it cannot do because the controlling receivership orders approve the receiver's actions every step of the way.
So just let me pose a hypothetical. It may not be directly enough. I have a piece of property here in Arizona, and I get a receivership order, and I tell the receivership I owe it 100%. Here's my debtors. And receiver starts the process of selling it, and at some point my brother comes up and says, hey, I own 25% of this property. And the receiver asks me again, I said, no, he doesn't own any of it. And the receiver says, okay, denying it. Does he really have no remedy at that point to pursue a claim against me for lying to the receiver about the ownership of the property?
Well, it wasn't the receiver that denied it. He just objected to the claim. It was the court that made the decision. So your brother's redress in that situation would, one, go to the appointing court and say, hey, allow my claim. Here's why it's valid. And MW2 did that.
But I
Yeah.
get that. And he should have
Yep.
arguably continued appeal. But he wouldn't have a separate claim against me for just blatantly lying about him not owning some of the property.
In this case, you're manning
Just asking.
So this, okay, if we go, they do cite some cases, the Bayless case out of, I believe it was the Fifth Circuit, and they say, that case generally said, if you conspire with the receiver or somebody who's immune, that doesn't prevent you from doing your own tort. So in that case, a receiver was appointed over a judgment debtor, went out to the judgment debtor's house and rifled through the property of the judgment debtor's, I think, girlfriend. The attorney for the plaintiff went out there with him and took some property, allegedly. The plaintiff sued the receiver and the attorney, claiming some tort. And the Fifth Circuit said, okay, yeah, we get it, the receiver's immune, dismissed, that's easy. The attorney, however, did his own wrongful act. And so that supported, at least on the motion to dismiss phase, that supported the claim by the plaintiff to the girlfriend, judgment debtor's girlfriend. The distinction there is that there's no alleged wrongful act by IMH here. It's just that we conspired to do what the receivership court ordered. That's not a valid cause of action. If IMH had gone out and punched somebody and committed a tort of assault and battery, just because it did that because it was told to do so by the receiver, that's still an own independent tort. So I acknowledge that. Here, by their own words, they're alleging vicarious liability. That means we didn't do anything wrong. That means we're going to be vicariously liable for the acts that somebody else did. And that's why this complaint doesn't even get off the ground. Did that answer your question?
I think so.
Okay. And just in reading that Bayless case and the cases they came out from, it was somewhat interesting because the authority developed out of a 1983 action cases where there was alleged conspiracies with a judge or say, and the judges were all immune, but the judge's alleged participation satisfied the state action rule. So for what it's worth.
Counsel, can we go back to the part that you cited on MW2's opening brief where you say that they do not allege any wrongful conduct, but only vicarious? Can you direct me to that portion again?
That's page 9 at the top.
Okay.
So let's see. The sentence starts with, rather, plaintiffs seek to impose liability solely upon IMH based on its vicarious liability, arising from the wrongful acts of the receiver during the receivership. The last portion of this page 9, MW2 says, and that, showing that the receiver acted wrongfully, in turn, I read that part.
Let me interrupt you because
Yeah.
I'm looking, and I don't think we're looking at the same page numbers, but I'm looking at.
Oh, I'm sorry, it's page 12.
Oh, okay.
I apologize.
All right, because at page 8, the last full paragraph, or where the second paragraph begins, Plaintiff MW2 further contends that the wrongful conduct and management of Seagoville by its acting general partner as actually performed, solicited, directed, and/or vicariously influenced or aided and abetted by IMH, also directly and proximately injured the interest of the OOP.
And what wrongful acts? All they've alleged is that the receiver stole property pursuant to court order. There's no wrongful act. And we conspired.
Well, and depriving them of their interest.
We conspired with the receiver to file a motion to deny their claim. It's just, I don't understand how that could be actionable. The court denied their claim after we filed a motion that says we don't allow them to participate in the receivership, and the court said, you're right, they're not going to participate in the sale of the of Seagoville property.
And your time is run.
I'm good.
Thank you, counsel.
Thank you, Your Honor.
You guys have got 4 minutes and 40 seconds to divide amongst yourself however you would like. We didn't get to the sanction part, so I'm not sure, unless you want to address, go ahead and tell me what you got to tell me.
If it please the court, Your Honor, I'm Brian Holohan. I represent Mr. Halstead, who's in the court and his law firm, because my opponent never made a single argument how the judge abused his discretion by not awarding sanctions. I don't feel it's appropriate for me to say too much more, except that considering how everybody seems to be struggling with what the right result here is, it sure seems to me the judge was correct in deciding that it wasn't unreasonable to have brought the suit.
Thank you, counsel.
I'm sorry, on the stay issue, if you decide to stay the action, you should at least affirm the decision to deny the sanctions, so we put that to bed, please.
Couple of quick things. It really is important to note, we had a lot of argument about whether IMH did or didn't do something, what the receiver did. All the allegations in this complaint are deemed admitted, deemed true for the purpose of this motion. I don't think it's appropriate to get into the argument about, well, what did the receiver do, what did he didn't do? We've given you plenty of facts about what we believe was the action between IMH and the receiver, which gives us a claim that we should be entitled to raise at the trial level. We should be allowed to amend our complaint. If, in fact, I want to jump to the stay argument, there is an underlying judgment for attorney's fees in this case, and if the court for any reason decides that either the action should be stayed at this level or at the trial level, then I would ask that that portion of the judgment also be stayed, or that the underlying action, the underlying decision by the trial judge be vacated, including the attorney's fees award, and the matter then stayed pending the outcome of the Aperian appeals. I think that's the appropriate way to handle the possibility of the stay.
I would not suggest that my question would indicate that's what we or I would do. I just was
I know.
one posing the question.
I'm just taking your rabbit trail and trying to take it to its logical extreme and button it up. Okay. This appeal and the mootness of a whole series of appeals that emanated from the lower court were dismissed as moot, and all of those appeals are now barred because somebody didn't go up to the Supreme Court and say, by the way, does dismissing as moot, is that with prejudice or without prejudice? I think it's 100% clear that the reason they were dismissed is because the judgment was vacated, and therefore all of the consolidated appeals were sent back to come back up if necessary once there was determination made as to what, if anything, was owed on that underlying judgment. So I just totally disagree that mootness means we no longer have a claim that we can raise on appeal. The no wrongful act issue, we've alleged plenty of wrongful acts, and their claim, by the way, that the partnership issue was not raised in the lower court, the charging lien statute. Mr. Halstead, in his response to the motion to dismiss, which we've incorporated in this case at page 8 Says the amended order places Seagoville in receivership. Despite the law, the charging orders are the exclusive remedy for a judgment creditor seeking to satisfy a judgment by the judgment debtor's transferable interest in a partnership or limited liability company, and cites ARS 29655, 29341. So that issue was squarely raised in the lower court. I would just encourage this court at this level to give us the hope of a remedy in the lower court based on well-pled allegations and the possibility that we should be allowed to amend to clarify anything that might be deficient and to add very specific claims for conspiracy and aiding and abetting. Thank you.
Thank you,
Thank you.
counsel. We will take this matter under advisement and issue a written order in due course. I thank you all for your very complicated arguments. It helped clarify some things in my mind, so thank you.